I'm just kidding.
You're all.
Yeah, I got some Sprite and stuff. Kels. Is it just me? Oh, yeah. They just need 2 more great games. 2 more perfect games.
And they're good. You think that was a fluke that they won?
No, I think it's been good all year. They beat Michigan 3 times. I mean, they ran through the tournament besides the Duke team.
Oh, cocky with it.
No, it's them. It's not me. I mean, they're doing it.
Duke could have lost 2 games before that.
Yeah, Duke was tough. I think it's going to be tough. I mean, Tech is tough. Auburn's tough. I mean, Auburn, Virginia, I don't know. They've been just winning
They've
close
been number
games.
1 all year.
Yeah.
Did you get to play in undergrad or no? Can you play at all?
Nope. Never. I'm not good.
You're not good?
I wouldn't know.
Do you think I could play?
I think you played in college.
As short as I am?
He ran
That's
track.
sweet.
She ran track.
He's lying, huh?
You ran track.
No, she played basketball too.
I ran track?
Didn't you say that? Okay, never mind.
He's making stuff up now.
She did.
So, while I kind of stall while I try to pull this presentation up, I did basketball, right, point guard, and then I ran track. And what's interesting is that I was like, I grew up in Southern Cal, and like basically with track, it's kind of like a culture there because you can run year round, and it's like a big deal, and you have like our team, we're the Striders, so we've got like gear, like real gear, jackets. We talk trash. It's a really big deal. And so I was undefeated, and I started getting cocky with it. And so when they would tell us to do the warm-ups to run around the track, I was like, I don't need to warm up. Like I'm the best player out here.
You were born ready.
So I would, and no one would tell on me because they liked me. And so I would run. You picked a great day to be late because I just got here. So I would run, and then when you get to the high jump pit, I would hide and sit down and then rejoin them on the last lap. So I never did the warm-ups, and no one told on me. And I was good. I did the 100, 200, 4x4 relay. Where I got into trouble is that I made it to state finals, right? And I was like, oh, I got this. I'm about to be the number 1 in the state. I got this. So easy. And wasn't practicing because I didn't need to because I'm a natural, right? And there was this girl that everybody was talking about that was like, oh, she's like amazing. We've never seen anybody run like her. She had the fastest time, not in the state, but in the whole country. And so as we got closer to the time, I started getting intimidated and kind of freaking out a little bit, thinking, dang, I might actually lose. I've been talking all this smack. I'm about to fall from my throne, right? And so my mom, who's always been like one of those people that like really pumps you up, she's like, oh, you just haven't had any real competition. That's why her times are better than yours. There's been nobody to push you. You can run faster. You don't have to. And I was like, yeah, I don't have to, And so I was believing it. So they have a holding area you walk into, and it's like a little area, and you wait until the next heat goes out. And so, I'm looking, everybody's sizing everybody up. I'm like 14. I was like, I got this. I'm looking at her, I was like, oh, I know I can run faster than her, whatever. And so then this girl walks in, and we all stopped and went, she walked in, her legs looked like stallions. Like, she looked like a freaking Olympian, like cut, like she got a trainer or something. She's 14. And she's a little taller than us, so we were like, wow. And we all knew that was her. Like, she didn't even have to say her name. And then what's so sucky is she was really nice. Hi, I'm Boo. Hi, I'm Boo. She's like, good luck. She was nice, and we didn't want to like her. So we get in the starter box, got my hands on both sides, got my cleats on, I'm down, and the guy says, runner, take your mark. Get set. Boom. I'm nervous. I jump the gun. Come back. So I'm like, okay, if I jump the gun again, I'm going to get disqualified. So we're back in our blocks. Runners, take your mark. Get set. Boom. So I'm running. So I had a weird running style. I ran like this, which is dumb. I don't know what I'm looking at, but I always have my head up. I used to piss my coach off. He's like, you're going against the headwind. So anyway, so I'm running, and like literally, I'm not exaggerating. This girl, when she ran past us, it was like a breeze. And she beat us in the 100-yard dash for like 50 yards. Like that doesn't happen in a 100-yard dash in your own age group. Like if an adult is running against you, but I mean, we just felt a breeze. She was waiting for us at the end. And, she's like, great game. Okay, I did get second. So when I teach in this like pipeline program, I tell the kids a lie that I won. And the reason I tell them is I said, your professor is really the fastest woman in the world because it was Marion Jones before the steroids. Yeah, isn't that crazy? She beat me bad. So that's my track story.
Have you seen that 7-year-old who's already beating like Olympic times?
7 years old?
Yeah.
Is she on YouTube?
It's a boy. Yeah.
If you see her, can you email her? I want to see her. She's probably my
a
kid
boy.
I don't know about. Just kidding. That was not nice. All right, so here's our plan. Here are our plans for the day. We are going to talk about Rule 15, which is amendment to pleadings. And then when we're done, I told you as of April, it's time. We have to start taking practice questions every class. So tomorrow there'll be practice multiple choice questions. Today I want you to see what the short answer looks like, okay? So they're just, there'll be different subject areas. It's just part of the review process. And remember the last week we were gonna have a review session. So you should be able between now and the end of the month to get all your questions addressed. But we have to start today so that you don't freak me out during exam prep time. It makes me all anxious when you guys are anxious. I need you to be cool, calm, and confident.
Like
All right,
you.
so let's start out, I guess, talking about Rule 15. And again, I'll send you the PowerPoint with respect to this. I might have already sent it. In general, amendment of pleadings under the federal rules are liberally permitted. In the early stages of litigation, I want to emphasize the early stages of litigation, especially before responsive pleadings are served, okay? Our first introduction to amendment to pleadings was which case? Anybody remember? Think about pleadings, responsive pleadings, first case, or whether amendment to pleadings. Remember, come on, the dirty doctor? Yes.
Was it the Waddle one?
No, but thank you. And I like that sweatshirt. It's a unique color. It's not boring black. What else?
The insurance, that's the insurance one.
Yes.
I can't remember the name of it.
What's the insurance case? Come on, the
Oh,
dentist.
with the Texas insurance?
With the dentist, right?
The dentist. Zelinsky, maybe?
I don't know
No.
the case name. I remember.
Stratford versus Zurich. We're there. All right, Stratford versus Zurich. Where remember the court gave the defendant permission to amend their counterclaim. Okay, so just a little reminder. I wouldn't ask you that on the test. I want to know that you can apply the terms. I'm not going to say which case did this happen.
April Fools?
No, not April Fools.
Not that late. April Fool's is when you're like a little late to traffic, not that late.
There was an accident with my bike. I'm sorry.
All right, so usually if something new comes up, right, it makes you want to amend the complaint or your answer. So there are basically three ways or three instances that come up in which you might want to amend your pleading. I don't know if I put that on the slide. I didn't, sorry. So basically, I'm going to tell you the three things you look for in a fact pattern, whether it's on the bar exam, because they test this every year on the bar exam without fail, or if you're out in practice or for my exam. So basically, again, there are three things or three instances where you might want to amend your pleading. The first one, you learn new facts during discovery. You learn new facts during discovery. Which makes sense because a lot of times you don't know, all of the facts surrounding whatever litigation you brought forth, and you're like, oh wait, he's got a co-partner, a co-business owner. I thought he was the sole owner of that comfy couch aid, but there's a co-business owner. So I want that business owner, meaning his partner, to be a part of this lawsuit as well. So one is you learn new facts during discovery. Another example of that, if you sue the defendant because they slandered you perhaps last year, you put that in your complaint, and then when you're in the deposition stage, the defendant also admits, yeah, I slandered her, she deserved it. I also keyed her car. So you want to include that damage or that act in your civil complaint as well. So again, you want to prove they did these things at trial. So as new things may pop up during the discovery, that creates an opportunity for you to again amend your complaint. New claims pop up. This one would be the keying of the car. Second scenario where you might want to amend your complaint is there's a problem with your pleading and you want to fix it. So if you see anything in a fact pattern that says there's a problem with the pleading, okay, so I've been real cool about people kind of being a little late throughout the semester. I get it, you have traffic concerns, but leave early enough to get here so those traffic concerns don't become an issue. I personally would have been here right at 9 o'clock, but I had students come into my office, not associated with this class, but my seminar, with a very pertinent family issue, and I couldn't turn them away. But that's one time, but you need to be here on time. So if this becomes a problem with the same people, I'm just gonna mark you absent for the day. You need to be here on time, because it's disruptive to my class to have to stop and wait on you to sit down. And it's not just you, Tabitha. You weren't the only one today, so I wanna make sure you know that. I'm not pointing it out. All right, so let's start again. So there's 3 fact patterns here. 1, you learn new facts during discovery. 2, there's a problem with your pleading and you want to fix it. So maybe you forgot to allege publication of the defamatory statement that you're suing about. This means that you left out one of the elements of your claim, which is a big deal. Perhaps the defendant has filed a 12B6 motion. Remember, that motion is they're trying to dismiss your case because you haven't done something correctly. Perhaps you didn't fully state your claim. Remember, one of the motions is failure to state a claim upon which relief can be granted. If they file that motion, you're going to want to make an amendment and fix that complaint so your case doesn't get dismissed. So again, anytime there's a problem with your pleading and you want to fix it. The third time that you're going to use Rule 15 to amend your pleading is new things happen that are in some way related to your existing claim. And I really want to emphasize existing claim, and we'll talk about that with our cases today, the Moore case specifically. So again, new things happen that are in some way related to your existing claim. New things happen that are in some way related to your existing claim. So say the defendant continues to slander you because they're ticked off in public after you file the complaint, and you want to recover for those additional torts as well, you can. Okay? Or if now, in addition to slandering you, they put it in writing, now it's defamation of character. They're like, how dare they make me look bad? And they write some scathing op-ed in the Courier Journal about what a sucky lawyer you are and dishonest you are. So that's something that's related to that initial claim, that's new, that comes up, and you want to amend your pleading to add that as well. So again, the 3 times that you're going to use Rule 15 is if you learn new facts during discovery. 2, there's a problem with your pleading and you want to fix it. Or 3, new things happen in some way related to your existing claim. So in all those scenarios, essentially, that I gave you, those 3, the plaintiff will want to amend their complaint, and Rule 15A is an apple, spells out what you need to do that. Before we look at the rule that I have behind me, Rule 15, I want to point out 2 terms that I think are important for you to understand, so that you understand kind of this whole amendment to pleading process. The first is responsive pleading, and we've talked about responsive pleading in earlier classes, but I really want to make sure you have a clear understanding of what it is. So an example, just as a reminder of responsive pleading, is an answer. So that's, again, the plaintiff files a complaint, defendant files an answer or response, which makes sense, responsive pleading. So you have an answer to a counterclaim would be another example of a responsive pleading, or to a third-party complaint. And remember, I told you Rule 7, if you Google Civil Procedure Rule 7, it lists all the different types of responsive pleadings. But I want to remind you that responsive pleading, it's what it sounds like. You're replying to a pleading that has been filed, okay? Second, I want to remind you that, well, that's it. I'm going to leave it at that. Okay, so let's go ahead and take a look at Rule 15, specifically Rule 15. What does Rule 15A1 provide? It says that a party may amend its pleading once as a matter of course, meaning without the other party or the court's permission. And they basically have 21 days after serving it where you can make the change. Serving it, meaning after serving the initial complaint on the defendant. If you realize you made a mistake, you've got 21 days to fix it, okay? If the pleading is one in which a responsive pleading is required. And second, 21 days after the service of a responsive pleading, so after the defendant's answer, whichever is earlier. So that kind of sounds confusing. And what does that really mean in a litigation real world sense? It basically means that Rule 15 has different time frames for amending a pleadings if you're a plaintiff versus a defendant. So it's important to note that Rule 15 has a different time frame to amend a pleading if you're a plaintiff, if you're a defendant. They have a different time frame to respond, okay, meaning to make the change. So here's the difference between the two, because this is what's important for bar purposes and exam purposes. If you are the plaintiff, this is your time frame. A plaintiff may amend the complaint without the other party's permission. So a plaintiff may amend the complaint without the other party's permission and without the court's permission. So a plaintiff may amend the complaint without the other party's permission and without the court's permission within 21 days after service of the defendant's answer. So within 21 days after service of the defendant's answer. And I'm just slowing down for the people that are handwriting, for people that are typing. So within 21 days after the service of the defendant's answer, or 21 days after service of a motion on Rule 12, whichever is earlier. So again, plaintiff may amend the complaint without the other party's permission and without the court's permission within 21 days after service of the defendant's answer, or 21 days after service of a motion of Rule 12. So remember, the defendant has two ways of responding to that initial complaint. They can respond with an answer, or they can respond with a pre-answer motion, which is going to be that Rule 12 motion. So essentially, they have 21 days. The plaintiff will be like, oh crap, I messed up. After service of the defendant's answer, or after service of a under Rule 12, whichever is earlier. Okay, and that comes from Section 15A1. Again, I just care that you know the rule for exam purposes, not what subsection it comes from. But I'm just telling you that in case you want to reference it later. So 15A1. Now let's talk about what the defendant's time frame looks like if they want to amend a pleading of some sort. And remember, pleadings are these documents that you're filing in the early stages of litigation. So a defendant can amend its answer. Oops, I messed up. I forgot to include this element. A defendant can amend its answer within 21 days of serving it without the other party's permission and without the court's permission. So a defendant may amend its answer within 21 days of serving it, or without the other party's permission and without the court's permission. So, that's kind of interesting. Do you think we should have that rule? Meaning the defendant, when you serve your pleading, your answer to a complaint or pleading, 21 days to make changes, is that fair?
Mine's even an argument that you think is over and then the other party comes back into the room and is like, and another thing.
Right, so do you think that's fair to have, they can keep coming back and adding stuff? Yeah.
I would think it is fair because if one side's able to alter it within 21 days, the only way to keep it fair is if both sides are able to do it.
What about if we say there's no Rule 15? I mean, Rule 15 was created, after the fact. It wasn't part of the initial Federal Rules of Civil Procedure. Prior to Rule 15 being being enacted, it was set up where you need to make sure you have a good understanding of what kind of claim you're bringing. And once you bring it, that's it. There's not this back and forth. Oh, this happened during discovery. Oh, then bring another lawsuit. But it was very precise. Because when you think about it, this ability to make amendments, it somewhat extends the litigation process, not substantially, but yeah.
You don't like it?
I like it in the sense that I think it's efficient, meaning if more claims come up that during discovery, why not litigate them all in one suit than making you go back and file another suit? But I've seen it manipulated sometimes, and I don't like it. Yes, you never
Also,
raise your hand. I'm excited.
I think like a plaintiff doesn't have to reveal their full story. Like they can just give you part of it, and then after they service you, they can wait to change it, and
At the
or
last
just like delay or something like that.
Yep, I like that. Yes, thank you.
So the plaintiff's rule is whichever one comes first, can they amend if the defendant amends their answer, like to be able to answer their amendment?
It's funny because I actually understood your question.
Okay.
And the answer is yes. It's kind of like the clock starts again. Yeah. So did you all understand our question? Okay, yeah, me too. It's just interesting because she looked at me like, I know this sounds kind of, but I hope you get what I'm saying, but I actually did. All right, so let's talk about Rule 15A too. That we talked about A1. What does it provide? And I don't have a slide for that. I apologize. Essentially, it says that in all other cases, meaning where the party can't amend based on one of the reasons given in 15A1, the party can only amend its pleading with the other party, so the opposing party's written consent, or the court gives them permission. Okay? And it says the court should freely give leave or permission when justice so requires. So the way Rule 15 works is if you're a plaintiff or defendant, if you cannot amend, meaning you've missed that 21-day window based on 15A1, 15A2 says you still have a chance to amend even though that 21-day window has passed, whether you're the plaintiff or the defendant. But you have to either get the court's permission or the other party to consent in writing, yeah, you can make the change. And so typically when you're out in the real world, attorneys, especially in a town the size of Louisville, they don't want a reputation for being difficult or jerks or whatever you want to call it. So typically if you're like, oh, I messed up, the plaintiff, the defendant's name, should be this, or I forgot to add this, typically they'll say fine because they want you to give them the same courtesy. Because at the end of the day, you can play the kind of cat and mouse game, but you want a good reputation in the field. You want, as they say, the civil process to ferret out the truth, and you can't do that if there's important things in an amendment. In a complaint that should be there that are not. So on a real world basis, typically people are not jerks about I missed a 21-day period. I need to make this amendment. Unless you're like that attorney from Mattel, okay, that guy, he's not gonna let you do it. But he has a reputation for being a butthole and not being cooperative, and that hurts him in the field. But that's essentially how it works. And again, I really want to emphasize that the court should freely give leave when justice so requires. If it's in the interest of justice, as we saw in the Aquaslide case, they say yes, you should move forward. And the Aquaslide case is one of my favorite civil procedure cases because I think it gives an example of the human aspect of if justice so requires, justice for whom, the plaintiff or the defendant? Because the Aquaslide case is an example of you're literally choosing sides and who's going to bite the bullet in this sense. All right, so that is Rule 15. Let's go ahead and hop into the Beck versus Aquaslide case that we have here. I don't know why I don't have my pen, it's so annoying. And we shall go from there. So let's go ahead and call on our two individuals here in the front again, Tabitha Douglas. And I forgot your last name.
And unfortunately, I wasn't able to retain or order the book.
Oh, you don't have your book as well. Wow. Okay, so we'll call you tomorrow. I'm feeling a little soft for you, Tabitha, for some reason, so I'm not going to call on you, but I was. But I am going to call on you for not having your book. You can't come to class without your book tomorrow. Okay, so let's do Attorney Going once, going twice. Pretty much called on everyone. Have I called on you, Attorney Fields?
Mhm.
I have. All right, we'll just go down the list. Hyman, where art thou? Not here, smart person. Alexander. How about April? I did. I see you over there.
I'm
Clack.
supposed to go today.
No, you're not. Why? Oh, you're from the suit?
Yeah, you don't
Oh, I
remember
forgot.
this?
You're honest. Is there anybody else I forgot? You?
You haven't called on me.
You wanna go?
Sure.
Yeah. All right, tell me your last name. Nair. Say it again. Nair. N-A-I-R?
Yeah.
Okay, so, I came up here with a pen and it really just disappeared, but I will remember. Nair. Okay, do you mind giving me the facts, please?
Yeah. So in 1971, Kimberly Village Home Associates ordered an Alkacide product from George Holt,
Okay.
who was a local distributor for the defendant Alkacide.
Okay.
So basically it got passed down a chain, like forwarded to Century Pool, and then they forwarded it to Purity Swimming Pool Supply.
Thank you.
A slide was delivered from Purity Warehouse to the Kimberly Village and was installed by Kimberly employees. On July 15th, Jerry A. which is the plaintiff, was injured while using the slide at a social gathering at Kimberly Village. And then on October 31st, a representative from Kimberly Village's insurance company informed Alkacide that one of their models was involved in the accident. In May 1973, Alkacide's insurance adjuster made an on-site investigation and interviewed people connected with ordering and assembling the slide. On October 15th, the plaintiff and his wife filed their complaint against Alkacide, stating that that they manufactured the slide involved in the accident and sought damages for negligence, liability, and breach of implied warranty.
Perfect,
Yeah.
perfect, on top of perfect. All right, so, interesting situation. These kind of product liability lawsuits, I'm sure as you know from Professor Rothstein, happen all the time. So what we care about is looking at how Rule 15 applies to this particular fact pattern. So Attorney Cantu, I believe? Did I say it correctly?
Yeah, it's on you.
Okay. What was the defendant Alkacide's initial response to its pleading?
So their initial response was that they believed that, so their insurer kind of told them that it was their slide, and all three insurers believed it was their slide. So they were just kind of going with it.
Okay. And what did they later decide to do?
So the owner of Alkacide came out and realized that it wasn't his slide, that he, I guess, made them all, or designed them all, and he amended the pleading. So there's two issues in this case, is the leave to amend and the separate trials. And so they amended the pleadings by, because
Okay, hold on. Thank you.
Oh.
It's okay. I'm glad you're prepared, but you're like, all right, so cool. So we know that the defendant Alkacide's initial response was, hey, look, we admit we manufactured the slide, but later moved to amend it and deny that they manufactured the slide. So what do the defendants do? They basically, plaintiff sues defendant as the alleged manufacturer. Defendant admits again in its answers and interrogatories that it manufactured the product. Attorney Cantu, why is the statute of limitations relevant in this case?
Because it expired after, I think after the owner found out, so 6.5 months after the statute of limitations, the owner visited the site and then found out that it wasn't their product.
Excellent. So that's a big deal. So you have agreed and admitted in a court of law that you manufactured the slide that caused this horrendous injury to these poor plaintiffs, right? Then you realize after the fact, after the statute of limitations is run out, meaning you can't bring another suit or you can't make the change, that it indeed is not your slide, right? So the defendant moves to amend their answer and say, hey, wait a minute, this isn't even our slide they're suing us for. And that's a big deal, because if it's not their slide, guess what? Summary judgment. It's not me. Why are we going to the jury? You can't sue me for a slide that is not mine, and ideally. So in terms of why the owner didn't know, as both Attorney Nair alluded to and Attorney Cantu said in a little more detail, since it was related to his question, he had relied on the insurers. Like, they had visited the site, they spoke with people that were on site, they visibly inspected the slide, and it turns out later the president of the company happened to be on site for a deposition. He inspected it too, and that's when he realized that that was not their slide. This happens all the time, like those cool super soakers that I live for in the summer with my little cousins. There's like the real super soakers, and then there's like the other knockoffs. And a lot of times people will sue the wrong company, the original manufacturer of the product, when it's really a knockoff product that caused the injury. So I feel like in this case the company did their due diligence. I mean, they sent out more than one inspector to make sure it was their product, and it's still sometimes those knockoffs are so precise that they didn't even recognize it wasn't their product. So in addition to seeking permission to amend its answer to deny manufacture of the defective slide, the defendant moved for what else, Attorney Nair?
They
Excuse me.
moved for a separate trial on the issue of manufacture.
Yes, what's that trial called, separate trial? Take your time, excuse me. Starts with a B if that helps. Do you know Attorney Cantu?
Only B I see is 42B, is the rule that they use. Let me see.
You said it, so why, just say it louder.
Say it.
Rule
42B?
Yeah, Rule 42B,
Ah.
and you said it's called a by what?
I didn't say that.
Didn't he say BC, or did I imagine that? He said it, I'm not crazy. So it's a bifurcated trial, so Rule 42B. You will cover that in Civ Pro 2, but essentially what it does is, in order to not confuse the jury, a lot of times there'll be a motion for a bifurcated trial, and not to influence the jury. You want to decide the liability issue separately, and then the damages, because a lot of times the damages can be so horrendous. This 5-year-old was maimed for life, or will never walk again, that it kind of, so we're human, so it can soften the jury, and even if the facts look kind of iffy, they'll say, this is McDonald's, they can afford to pay this poor little girl's parents to take care of her for the rest of her life. She lost both legs, in this aqua slide accident. So for that reason, Rule 42B is there to separate trials in instances like this, because in this situation, there were some pretty severe injuries that were done. All right, so what does the district court do regarding the defendant's motion to amend its answer, Attorney Nair? What do they do? The trial court, do they grant or deny the defendant's motion?
They granted.
Okay, and what about the bifurcated trial?
I believe, or we hold on pages. Yeah, so they granted that as well, because there was a substantial issue with like the material fact that they had not made.
Okay, you said that correctly, but can you say it louder so your peers can hear you?
Yeah, there was a substantial issue of material fact, so they said that they would obviously grant that.
Yes, grant the motion. So we know the trial court grants the defendant's motion to amend its answer and grants the motion for this bifurcated trial. Who wins at trial? Well, we know the defendant wins at trial on the issue of who manufactured the slide, obviously. The trial judge then enters a summary judgment dismissal, which is what she's referencing, saying, look, there's no material fact for the jury to even decide, because it's not even their slide that has caused the injury. So, summary judgment, there's no reason to go before a jury. And so we know the plaintiff appeals, right? I'm gonna read a specific quote from the case. It says, on motion, the defendant, a separate trial was held on the issue of whether the defendant designed, manufactured, or sold the slide in question. This motion also resisted by the plaintiffs. The issue was tried to a jury, which returned a verdict for the defendant, after which the trial court entered summary judgment of dismissal of the case. So we know that obviously Rule 15 applies here because we're dealing with an amendment issue. Attorney Cantu, what section of Rule 15 is the court interpreting in this case? What section?
15A2.
15A2. All right, and again, that provides that in all other cases where the party cannot amend via Rule 15A1, a party may amend its pleading under what two circumstances, Attorney Cantu?
Under what?
So based on
Written
15A2,
consent or of the adverse party, and then leave shall be due again, or with written consent or the court's leave.
yes. All right, so I'm like, it's right there.
Yeah.
Written consent by the opposing party, right, or the court gives permission or leave to do so. All right, so why couldn't Attorney Nair, the defendant, amend its answer as a matter of right under Rule 15A1? So you don't need to look at the book, you know why? You already know the answer. So the only time you can't do 15A1 is if what?
Because it wasn't within 21 days.
Yeah, it's not harder than it is. So that's why I was like, you don't really need to look at the book. All right, so yeah, so if you don't make those 21-day time frame requirements. So because the time frames for the amendment, again, under 15A1A had already passed, so the only way for the defendant to get their answer amended was to get the court's approval. Remember that under 15A1, the defendant can amend its answer within 21 days of serving it without needing the other party's permission or the court's permission. Again, if the defendant fails to do so within that 21-day period, the defendant has to get the court's approval or written approval from the opposing party. Attorney Cantu, what is the issue on appeal here? What is the issue?
So the issue is leave. So what, should there have been a leave to amend? Should the trial court have granted that, and should they have granted separate trials?
Yes. So on amend, what the appeal is, what they're trying to figure out is whether the trial judge erred, as he said, in giving the defendant permission to amend his answer, and whether the trial court was in error for allowing that bifurcated or separate trial to happen. Attorney Nair, who has the burden of proof in a motion to amend a pleading under Rule 15A2? Who has the burden of proof?
The plaintiff, I think.
Is it the
Sorry,
person-
the party opposing the amendment to show such prejudice.
Yes. Why do you think it's set up like that?
Because, like,
They're the ones that are going to be affected by it, right? So they should have the burden of saying, hey, Your Honor, don't allow this to go through. The opposing party has to show the burden of proof. This isn't a good idea. I'm going to get totally screwed in this, right? Don't allow this amendment to happen. So the burden is on the opposing party, as she said, to the amendment to show such prejudice. So in your textbook, it says that in a ruling on a motion to amend, the trial court must inquire into the issue of prejudice to the opposing party in light of the particular facts of the case. And in that section of your case, they're referencing a case Standard Title Insurance Company versus Roberts. Again, not on the exam. I care that you know the sections is a Rule 15, but that's where the court, that's what they're relying on. And they held that undue prejudice must be shown. So you have to show there's some type of undue prejudice. Attorney Cantu, what is the standard the court must use in determining whether to grant a motion to amend a pleading under Rule 15A2? Specifically, what is it? What should they grant? What do they have to consider?
Well, so the court cited two cases. You stated the rule from the Hanson Hunt Oil, the burden on the opposing party. So I think you're asking me about the absence of undue influence, bad faith.
Okay. Keep going.
Bad faith, repeated failure to cure deficiencies by amendments, and this was coming from the case they cited, Bowman v. Davis.
Yes.
Undue prejudice to the opposing party by virtue of allowance of the amendment and utility of amendment.
Keep going.
The
You're right.
relief side should freely be given, however, in the discretion of the court.
Yes. So the specific section, I was trying to find a page number, in the case, it says, quote, if the underlying facts or circumstances relied upon by a plaintiff may be a proper subject of relief, he ought to be afforded an opportunity to test his claims on the merits. In the absence of an apparent or declared reason, such as undue delay, and then this is, I'm reading literally from your book, bad faith or dilatory motive on the part of the movement, repeated failure to cure deficiencies by amendments previously allowed, undue prejudice to the opposing party by virtue of allowance of the amendment, futility of amendment, etc., the leave sought should, as the rules require, be freely given. In other words, what you should write down is, if no bad faith, no undue prejudice, no bad faith, no undue prejudice, or undue delay, if no bad faith, no undue prejudice, or undue delay, bad motive, we're almost done, or repeat failure to cure deficiencies, then a party should be allowed to amend. So that is the standard the court looks at if the court is going to allow the amendment. So if the opposing party doesn't agree to do it. So again, if no bad faith, no undue prejudice or undue delay, bad motive, or repeat failure to cure deficiencies, then a party should be allowed to amend. Awesome. All right, so what's the court's holding and reasoning with respect to whether the district court abused its discretion when it allowed the defendant to amend its complaint? We know that they said it's evident from the order of the district court that the exercise of its discretion in ruling on the defendant's motion for leave to amend, it searched a record of evidence for, again, bad faith, prejudice, undue delay, which might be sufficient to overbalance the mandate of Rule 15. Basically, they said that the defendant, in layman's terms, in investigating the circumstances surrounding the accident had not been so lacking in diligence as to permit denial of the right to litigate the factual issue of the manufacture of the slide. In terms of bad faith, the court said no. The court noted the fact that the defendant, initially concluding that they had manufactured the slide, relied upon the conclusions, again, of 3 different insurance inspectors, companies, and the court found further to the extent that blame is to be spread regarding the original misidentification of the slide, and they said the blame should be shared equally. So they didn't feel like there was bad faith on the part of the defendant. To the contrary, initially they willingly admitted, yes, we manufactured the slide. And they said, it was essentially what they were saying was no bad faith. It was a understandable mistake because 3 other people made the same error as well. In terms of prejudice, the court said no. Well, we don't think there's no prejudice in this situation as well. They said the plaintiff, because even though the 2-year statute of limitations had run, it permitted the amendment. By permitting the amendment to the complaint doesn't mean the plaintiff is automatically going to lose the case. It just means that they're able to dispute this factual issue in trial, and they didn't think it would be prejudicial to the defendant either. So they're essentially saying, look, we're not denying the plaintiff an opportunity to still litigate this case, but it is relevant who manufactures the slide. It's in the interest of justice for that amendment to be made for those purposes. I struggle with that because, when you look at this case, the plaintiff is totally getting screwed. So it's past the statute of limitations. Yes, a mistake was made about the manufacturer of the slide, but the plaintiff can't go and sue the right person. Like, the statute of limitations has run out, and the damages in this particular case were really, really high. It was over $2 million. It was $2,225,000. That sucks. and I can see how some judges might say, you know what, yeah, they didn't manufacture the slide, but they said they did, this Aqua Slide company. And the statute of limitations has run out, so it's in the interest of justice to allow this suit to go forward. Aqua Slide can afford it, they have insurance, that's why they have liability insurance. And this poor person that has over $2 million, that's the severity of their injuries, should be compensated, but now they're screwed. Is anybody not kind of thinking that's unfair to the injured party? But then look, what about the company? Why are they paying for an injury that their slide is not responsible for? So, show of hands, who should take the hit? The injured party or the big bad Aqua Slide company?
The insurance people.
Aqua Slide? Show of hands, who says Aqua Slide? Almost 50%, all right. Those of you that said Aqua Slide, anyone want to give an argument as to why that's fair when it's not their slide? Yes.
Because their insurance said it was. 3 people said that it was. So could they go after the insurance people?
I mean, they could, but
All 3 of them together?
it was an honest mistake. They could negligence
3 people
technically.
made the same mistake?
That's why I think the slides. That's why I was giving the example about the super soakers. It obviously was a very good copycat, right? Honora.
I don't think it's fair because you can consent to personal jurisdiction, so I feel like you should be able to consent to fault, and I feel like that's what they did.
Great article. That'd be a great little RV note. But the difference though is you consent to personal jurisdiction knowingly. They didn't knowingly consent to, like, it's not like they knew it wasn't their slide and they said, yeah, we manufactured it, right?
I feel like, but to their knowledge at that point, it was not. I don't know. I just don't think it's fair.
To the injured
plaintiff,
party.
Yeah.
What do you think?
I think they knew the amount that they were being sued for, so if it wasn't worth it for them to do more than they did to make sure that they were the right party being sued, then at this point, that's their
falls
fault.
on them.
It's just been too much time.
Yeah, because remember we read an earlier case where the judge said, look, it's not my job to help you figure out subject matter jurisdiction. You need to decide. I mean, that's your due diligence as an attorney. You need to decide and determine what the citizenship or domiciles of each party is and whether you indeed have subject matter jurisdiction to file your case in my court. Not my job. Dismiss the case. He's like, wait a minute. No, the case is dismissed. You can take the same attitude. Not too bad. You should have made sure if you know that. And they said somewhere in the case that this has happened before. So you should have an expert trained at the level of that president's knowledge that can go on site and all they do is make sure it's their slide that's being manufactured. So in one sense, why should the injured party get screwed? Because they made a mistake. Their inspectors made a mistake, right? Does that change any hearts and minds? You said no still. Why not for those of you that said no that are willing to share? Yes, Jessica. I mean, not Jessica, Emily.
It's not their slide. This is not a case of like a smoker where it doesn't matter the brand. Like if someone smoked 5 different brands of cigarettes and then they got cancer. This is very purely not their slide. What they can do is say, how about you go after the insurance people because they didn't do their job correctly. It might have been an honest mistake, but that they need to go after the insurance people who made, all 3 of which made a mistake, or they need to, as bad as it sounds, these poor kids aren't gonna be able to deal with it, because it's not fair that someone be punished because of a knockoff.
You're right. After then Jessica, and then we'll move forward.
Well, I'm just trying to think of an argument, because I don't think it's really fair to either of them, but the injured party needs recovery. It's not really coming out of them. They have the insurance, and when it comes to knockoffs, they're looking at the original party's patents and everything to make these products. So it would be similar enough that, I mean, even Aqua Slide could look and say, well, maybe this is something we need to look at so we can prevent other suits. I mean, it just seems like they're better off being able to pay.
Jessica.
I mean, I'm kind of with Taylor and Emily on this in that both the plaintiff and the defendant got screwed over by these insurers because they both relied on what the insurers were saying. Like, yeah, their slide, so it's like, it's not even just the defendant relied on a false conclusion, it's the plaintiff relied on that same conclusion with the original answer. So it makes more logical sense to me for both parties to go after the insurers for negligence, because it was because of their false conclusion that they landed in this situation to begin with.
Absolutely. So it's a real, and thank you for sharing. I appreciate the input. Sorry, we've run out of time. But, you know, from a policy perspective, this case really presents a ethical dilemma in a sense. On one hand, the defendant, as many of you have stated, should not be hit with liability when it really didn't manufacture the slide. Plus, the defendant made a good faith mistake trusting the insurers. On the other hand, what about the plaintiff? You know, if the court permits the amendment and it's after the statute of limitations has run out, as we've seen here, which is the case, and the injured plaintiff gets no relief at all. And so it's too late to sue the actual manufacturer of the slide. And so this shows some of the downsides of Rule 15. And depending on your perspective, some of the upsides as well. So for the sake of time, we're going to move on to Rule 15C. Rule 15C. All right, so Rule 15C deals with amendments to pleadings after the statute of limitations has run out and establishes this concept of relation back. Okay, so they have another option for when the statute of limitations has run out. The problem comes up in basically two ways. One, the plaintiff may seek to amend their complaint to add a new claim after the statute of limitations has expired. So again, these are two fact patterns you're going to look for. The first one is a plaintiff seeks to amend their complaint to add a new claim after the statute of limitations has expired and after the period for amendment as a matter of right, meaning 15A, so after that time frame. Second, a party seeks to leave to amend to join a new party, right, or change an existing party's name, again, after the statute of limitations has run out. So the issue of whether the parties will be able to amend their pleadings in those two scenarios is what we call the concept, again, of relation back. Means that if the rules in 15C have been satisfied, the new amended pleading will be treated as though it were filed in an earlier timely manner. So it's kind of like literally going back in time, which is interesting. To satisfy Rule 15C, you will be deemed to have related your new pleading back to your old pleading, and so your claim will not be barred by the statute of limitations. Part of my thoughts with this is, what's the point of having a statute of limitations if you're going to allow me to do a relation back, right? What's the point of me doing that? Rule 15CA1, I have up here a new claim. The first relation back rule is contained. The first one deals with a new claim. It provides, again, that if the applicable statute of limitations allows relation back between the old pleading and the proposed amended pleading, then the amended will be permissible, the amendment. When it says that the statute of limitations so requires, statutes, when they're created, whatever type of law it is, they will stay explicitly in the statute whether or not they allow relation back. Some statutes do allow it, some don't. So that's why it says if the statute of limitation allows relation back. And then second, if you're trying to do a new claim, you need to remember that Rule 15A1B provides that relation back is permitted if the amended pleading, and this is very important, arose out of the same conduct, transaction, or occurrence. We call that the same transaction or occurrence test, okay? So that's what you're looking for. Did it arise out of the same car accident? Did it arise, this new claim that you want to add, out of the same contract deal? Did it arise out of the same act of negligence? So that's very important. So it's called the same transaction and occurrence test, but that's what you're looking for, the same. And I'll later on give you more details of what you look for in that test, more elements, okay? And so let's go ahead and try this. Well, we'll do this one really quick. So Rule 15C1C is also relevant. That's again if you want to change a party's name in an original lawsuit. This addresses a much more difficult situation. It's one thing to add a new claim, but a new party? Like, wait a minute. So it applies when a plaintiff seeks to add a new party or change the name of an existing party. And essentially you need three things. One, again, the claim has to arise out of the same conduct or transaction as stated in the original complaint. Two, it has to be done within 120 days. So it has to be done within 120 days after filing the original complaint. And then three, it has to be within the same period, 120-day period. The defendant knew or should have known that the action should have been brought against it, but for a mistake considering the proper party's identity. So there was somebody who filed a lawsuit against my brother for an unpaid bill that he had in civil court, and they accidentally made the complaint to Otis Evans Sr. when it was Otis Evans Jr., my brother. So they made it to my dad. My brother thought it was funny, so he's like, I'm not saying anything, right? He was like 23, he's always getting in trouble in that little time frame. And yes.
Sorry. Is it 120 days or 90 days?
It's 90, 120, well, 120 is different, so let me clarify. So keep the 90 days, the 90 days is correct. Wait, this is 15C1C12. 90 days, and I apologize for saying 120. All right, where was I? Oh, so they made it to Otis Evans Sr. and it should have been Otis Evans Jr. So that's a change. It matters. You're bringing the lawsuit against the wrong person. The Moore case is kind of short, so I kind of really want to get through it. So let's do Moore case. More. Go ahead.
So Judith Moore went to Dr. Baker about a blockage in her carotid artery.
Okay.
The recommended surgery. Moore signed a consent form. She was severely disabled from the surgery and sued Dr. Baker.
Okay.
Her initial complaint was that he violated Georgia's informed consent law by failing to advise her of an alternative therapy. August 6, 1991, after Baker filed a motion for summary judgment on the issue of informed consent, or that date, he did that, and then on the 26th, August 26, 1990.
Okay.
Let me look at this again, make sure I got it right. August 26, 1991, Moore moved to amend her complaint to assert allegations of negligence by Dr. Baker in the performance of the surgery and his post-operative care.
Excellent and excellent. So, in this Moore case, we have, we know that Moore signed the consent form. The operation went very badly. She was severely and permanently displayed, as Attorney Cantu said, and she sues Dr. Baker because she's ticked off. In her original complaint, which is what we care about, which was filed the last day permitted by the statute of limitations, alleged that Dr. Baker had violated Georgia's informed consent law, and by failing to advise her of alternative therapies that were available as opposed to cutting her, doing a surgery. What happens after the plaintiff filed that complaint? Basically, Dr. Baker filed a motion for summary judgment on the issue of consent. In August 26, 1991, Moore moved to amend the complaint to assert allegations of negligence by Dr. Baker in performing the surgery in his post-operative care. So originally, again, her complaint said, oh, he violated Georgia's informed consent law, and now she's saying, oh, I want to add another new claim altogether, which is going to be negligence. Attorney Nair, what is the district court's holding and reasoning in this case?
For the whole,
Did they deny or grant plaintiff's motion to amend?
So they denied it because the amended complaint didn't relate to the original one. So the original complaint talked about, it had allegations about actions before the surgery, and then the amended one talked about during the surgery. So they were different conducts and happened at different times.
You're saying it correctly, different? The alleged conduct happened at different stages in this process, correct? Yeah, okay, so we know the district court denied the plaintiff's motion to amend her complaint on the grounds that the newly asserted claim again, was barred by the statute of limitations. Moore appealed to the district court, and the court says that the critical issue in 15C determinations is whether the original complaint gave notice to the defendant of the claims asserted by the plaintiff. Well, no, if your original complaint is based on consent, that's not giving me notice as a defendant that I need to start creating a defense for negligence. Like, that doesn't give me proper notice, okay? The plaintiff relied very heavily in her appeal on the Asserball case. In Asserball, the original complaint alleged negligence, right, in the performance of amniocentesis on the plaintiff, resulting in injury to the unborn child. In that Asserball case as well, the statute of limitations had expired, and the plaintiff sought to, again, amend the complaint to add a new claim that the doctor failed to obtain her informed consent prior to performing the sterilization procedure. The district court in that Asserball case that the court relies very heavily on basically said that Asserball would have any claims Asserball would have arising from the amniocentesis procedure, including a claim that the doctor should have revealed the procedure had caused a fatal injury, would have provided her with adequate notice, and therefore the amendment should have been allowed. But the court says this is very different in this particular setting. As Attorney Nair said, in Asserball, the allegations asserted in the Moore complaint, Moore versus Baker, contained nothing to put, again, Dr. Baker, as I previously stated, on notice of the new claim of negligence. There was nothing to let them know that maybe I need to start preparing a defense for this. Even the court said if you look at it given it liberal construction, there's nothing in Moore's original complaint that would make reference to any acts of alleged negligence. The original complaint, again, focuses on the defendant's actions before the plaintiff decided, remember, informed consent, to undergo the surgery, but the amended complaint focuses on defendant's actions during and after the surgery. So Moore would have to prove a completely different set of facts with negligence as opposed to the informed consent, and that would not be fair. So they said they must conclude that Moore's new claim did not arise out of the same conduct, transaction, or occurrence as the claims in the original complaint because of that time frame. Now, some people make the argument that that's not fair because it's still part of the same. If you looked at the full opinion, the attorneys say, look, it is part of the same transaction and occurrence because the medical procedure process starts from when I go, have my consult, until the procedure is finished. That's all part of the same transaction occurrence. I have this ailment I'm trying to get treated, and that they didn't think it was right for the court to separate it and make that distinction. Do you agree with that it should be part of the same transaction occurrence? Should they be that nitpicky to say, well, this is pre-surgery, this was during and after? It's all part of the same incident, don't you think? No?
I agree.
I think, like you said, or like it said in the case, that there are different things that the doctor's preparing for. The informed consent would be different than preparing for a negligence case. So I just think it'd be fair for him, but
To have to be.
I think he should be on notice of what he's getting sued for.
Yes, thank you.
I think that she was kind of being, she was upset that she wouldn't be successful in her informed consent. So then she tried to do the negligence. So I don't really feel like the lawyer did the due diligence at first. Because they kind of realized, oh crap, I'm gonna fail.
Exactly.
It's this, so I'm on the doctor's side.
I like that. Anybody else? Jessica, go ahead.
Well, and also in the original complaint, they indicated that maybe everything was done reasonably and that there was no negligence. And then later they amended and tried to say that there was.
I think Jessica had her hand up.
I was just stretching.
Oh. All right. So Rule 15, what's important about Rule 15 is that it allows you to make amendments to pleading. So if I made a mistake, I need to add a new claim, thank you so much, or a new party, when can I do that? And so relation back allows you to do it. So there's Rule 15 covers two areas. They cover, you guys both have one? Okay, I didn't know if I had enough. So they cover two areas. Thank you. They cover, in that 21-day filing period, where, that 21-day filing period, where you can make a change on your own, and then after the 21 days, hopefully the opposing party will allow you to do it. Or the court will say it's in the interest of justice. If the statute of limitations has already run out, then you have the one last ditch effort, which is the relation back option of saying, you know what, we're acknowledging that even though the statute of limitations has run out, the court is going to allow you to still make that amendment if it arises out of the same transaction or occurrence. So what's important for exam purposes, I've never not tested Rule 15. So I'm guaranteeing you I'm going to test it. What I care about is that you know under what circumstances, if it's the plaintiff or the defendant, that you can make the amendment, in what time frame. Look at the dates on the test. Is it within that 21 days? I'll give you dates. I'm telling you ahead of time. And you'll decide, oh, it's within the 21 days. It's okay. Or it's not okay. I will say in the fact pattern, the statute of limitations has run out. Ding, ding, ding. So you're going to be thinking, okay, relation back. Or is it in the interest of justice? So just make sure that you understand Rule 15. I will give you hypos on that after you have a chance to let it sink in. But I'm brutally telling you bluntly it will be on the exam. So make sure you know. All right, so let's do a flashback here. Personal jurisdiction. This is what a short answer would look like on the exam. And I'll say you can answer in 2 to 3 sentences for each one.
You said how many sentences?
I'm just giving out a number, but it'll be just a couple of sentences. Okay, so you'll have a limit. So we have a lawsuit that's been filed against Katy Perry, defendant, for copyright infringement. In her affidavit, Katy claims that she has no control over the commercial distribution of Dark Horse. Her only contacts with Missouri are 4 concert performances during 2011 and 2014, which were part of international tours. Moreover, the concerts were arranged through and were services rendered by Perry to her California touring company, Katy Perry Incorporated. Defendant Perry, further avers that she has no involvement in the commercial distribution of the song anywhere, including Missouri. Dark Horse was offered for download and listening on a website accessible in Missouri. The website was owned and operated by a third party. Plaintiffs argued that the impact of the alleged copyright infringement was felt in Missouri, where 2 other plaintiff hip-hop musicians lived. First question, is this a civil or criminal case? Civil. We know it's civil because it's dealing with monetary damages. There's no criminal statute or law that has been, that has been whatever. All right. What type of in personam jurisdiction may be possible here? So we know the defendant is Katy Perry. And where is she domiciled?
California.
All right, so Katy's in California. What about the defendant?
Missouri.
Say it louder. Missouri. All right. Okay, so what other facts do we need to know here? What cases come to mind?
The internet case.
Yeah, the sliding scale, Pavlovich, right? Is this the site where the music was? Was it downloaded? Was it a site where it was you're able to get information where they're just posting information, or was it more interactive?
Interactive.
Yeah, a little more interactive. So what does that tell us?
That she's not.
It's going to establish personal jurisdiction.
Say it louder.
It's going to establish personal jurisdiction.
Okay. Where?
Missouri.
Missouri. All right. So we know Missouri. We've got the sliding scale equals personal jurisdiction. Any other types of jurisdiction might be possible here? What about in rem?
There's no property. Well, actually, no, I take that back. If, is copyright infringement, does that have any bearing on it?
You tell me.
Well, but copyright trademarks, those are considered to be like intellectual property.
Okay.
So I don't know if, I can't remember if that would count in property in terms of like in rem and quasi in rem.
What does your gut tell you?
It does.
Okay, so when in doubt on the exam, make the argument. It's not whether or not I agree with you. It's do you know the law? Make the argument that this is considered property and the dispute is about the property. It's considered intellectual property. I will give you credit. I want to know that you know the difference between in rem, using the sliding scale, right? Specific, general jurisdiction. What about, what personal jurisdiction questions should be asked to determine whether Missouri may assert personal jurisdiction over Katy Perry? We asked about the website. Is it more, how interactive is it? Any other questions we should be asking? Do we care where they're incorporated? The defendant?
From what we saw, since something's on the internet, it could be anywhere at any time. So
Yeah.
it's not quite fair to go just after we're incorporated.
Absolutely. So as soon as you see an internet fact pattern, the point is you automatically apply that sliding scale. You feel like you still understand that sliding scale? If not, please review your notes. I have run out of time. I'm going to give you another fact pattern to look at and we discuss at the beginning of the next class. So hold on before you leave. Yes and no.
Did you ask about stream?
Ask Cross, yeah. Professor Cross, he teaches intellectual property. I know there's a statute that applies to that, that's outside of the. They have their own set of rules for
Thank you.
copyright.